Hey folks, James Abrinio coming to you from Abrinio Law. It's now June 29th, 2025. And if you're from Virginia, you probably know this. If you're not from Virginia, you probably don't know. July 1 of every year is usually a big time, at least when it comes to Virginia and our laws, because July 1 is the typical time frame when the new laws that were passed by the legislature, unless there was some type of delayed enactment, will usually come into effect that year. So if you're a Virginia resident, July 1, always be on the lookout for new laws coming into effect. And of course, this year is no exception. So I figured I'd take this video, a little bit of time to discuss some of the new important laws I think that are coming into effect here in Virginia. Now, because my practice focuses primarily on traffic and criminal as well as personal injury, that's going to be the focus of this video. I'm sure there's other laws that are certainly important when it comes to other realms, and there's probably other laws within this subject matter that's probably important, but I'm really focusing on the ones that stood out to me the most, and we'll go from there. Every year there's a ton of new legislation coming out of our General Assembly. I also want to throw a shout out to the lawmakers here in Virginia. They're part-time employees that work for our community. They go down to Richmond for at least a month, usually a lot more, to put this work together to advance Virginia. So thank you, and a shout out to you guys for the efforts here. So let's begin. So the first one is a new Class 1 misdemeanor if you fail to yield for pedestrian and serious injury results. This was, I think, a good advancement. I can tell you, representing victims, how many times I couldn't say when I would be representing somebody would be very seriously injured in an accident. And the worst that could happen to the person that severely injured them was a traffic offense, essentially a failure to yield. A lot of times, even in Fairfax County, a failure to pay full time attention, which is not even a traffic infraction, it's no points. So I think from a victim standpoint, this is an advancement. Now, of course, if you're looking at it from the criminal defense side, anytime you have additional criminal liability, that's always concerning. But I think when it comes to our roads and the caveat that somebody has to be severely injured or death results, I think that is an important caveat, and I think it adds protections. Look, we're in a very high populated area. There's a lot of cars around, and fortunately, in my personal injury world, and sometimes my criminal defense world as well, I see very severely injured people or tragically killed, and we just need to be safer on our roads. Next one, let's talk about reckless driving. Here, they have essentially expanded reckless driving to encapsulate exhibition driving. I'm not going to get into the details in this video. I would recommend you go look at the statute specifically, but in it, it defines exhibition driving. And just so you're aware, the statute I'm looking at is Virginia Code 46.2-865, as well as through 867. It defines exhibition driving. And it's kind of the things that you're thinking about: racing, stunting, as they call it, the kids call it these days. But go look at the statute. The long and short of it is, if you're doing driving ridiculously in cars, now there are enhanced penalties. So you just need to be very careful, especially if you're a new driver. Again, I've represented people both on the personal injury side as well as on the criminal side where serious injuries have occurred because people are trying to show off. It ends up having devastating effects for the victims. It also has devastating effects for the individual drivers, because not only does it affect them psychologically, having caused a serious injury, it can have devastating effects criminally speaking. So, and for your life as well as from the civil side. So just be careful. Stop showing off. People don't care about your car and all those kinds of things. Just learn how to like yourself for what it's worth. So, and I remember being young once, doing stupid things as well. by the grace of God, I didn't get in trouble. By the grace of God, I didn't hurt anybody. So I'm not sitting here lecturing you as if I'm perfect, but just be careful and just be aware of what can happen. Next one is a small but I think important change. Adults previously were required to wear seatbelts only if they're in the front of the car. Now it's required in the back seat as well. A minimal fine, $25. It's just an incentive to get people to wear seatbelts. Again, representing injury victims, seeing a lot of car crash cases. I can't tell you how many cases that I'm surprised people walked away from when they should have been killed, and had they not been wearing a seatbelt, they would have been killed. So just put the seatbelt on. The next one, there's a new enhancement of crime for stealing the mail. It's now a Class 6 felony. This is on top of federal offenses you can be charged with. So don't take people's mail. I fortunately haven't had my own mail stolen, but I've heard a lot of folks that have. This affects people personally. People are waiting for benefits, letters from friends and family. Also, businesses are affected as well. So just stop stealing the mail. Next one is, this isn't really a new law coming into effect, but in, I think, 2023, the legislature, and maybe even earlier, it might have been 2021, the legislature passed massive reforms to our expungement statute, broadening when charges are expungible, also distinguishing between sealing and expungibility, and what expungements are. In large part, this is a huge advancement. Honestly, I never thought I would see this kind of change in my lifetime as a lawyer here in Virginia. It happened. Super happy about that. But there's some complications on the back end, I think, for implementation. So they delayed these effects until July 1 of 2026. I don't know what ends up happening now and between now and then, but it seems like all hands are pointed towards it going into effect and no substantial changes. And so I'm just hoping at the end of the day, even if you have to wait one more year, this is much needed relief. So I'm happy it's still on the books. I'm glad it wasn't tried to pulled back and the rug pulled out from behind of us or underneath us. So now let's move on to civil. This one is a very nuanced statute, but a very needed one. And I just want to throw a shout out to the legislatures as well as the Virginia Trial Lawyers Association for pushing this much needed change because it unfortunately wasn't clear that it was needed unless you were in the injury world. What was happening is folks were suffering sexual assaults, serious sexual assaults by employees of businesses. And our Supreme Court essentially narrowed the law so significantly to where holding an employer liable for that employee's serious assault or serious sexual assault became virtually impossible. I think the language was essentially they were requiring is you had to show that the employee was actually doing the assaulting behavior for the benefit of the employer, which obviously that's never going to happen. So much needed reform here. There's now obviously I would want this to go forward, but essentially there is imposed a broadened ability to impose civil liability on employer for the employee's assaults or sexual assaults. And this is really in the context of language used in the statute called vulnerable victims. So the new statute expands the meaning of this course and scope of employment. So what actions are in the legal course and scope of employment, employees' actions for the employer. And it also defines vulnerable victims. The long and short of it is we're looking at settings like hospitals where you've got patients that are physically vulnerable. You've got long-term care residents, so elderly and disabled folks, that now under this new statute, it is possible to seek civil liability in the event that they're seriously assaulted or sexually assaulted. Tragically, these things happen, and I think that this is an advancement and a much needed advancement in our civil law. Hopefully it gets broadened even more, and as the statute gets litigated more to define what exactly is a vulnerable victim and what exact context, hopefully that will expand it as well. But again, I'm just happy that this move was needed. This change was moved. So awesome. Next one is again a nuanced one on the civil side. but it essentially increases the threshold when law enforcement are required to author a police crash report in car crash cases before the minimum value damage that the officer was required to detect was 1,500. Now it's up to 5,000, so it's increased. And effectively, what this means is, in order for a law enforcement officer to be required to create a police crash report, they now have to see more damage. Now, a couple issues coming out of this. This is going to be in the context of car accident cases. Usually, when I'm representing individuals injured in accidents, I use a police crash report to determine whether or not there's witnesses, whether or not the other person was charged, the mechanics of what the accident, how the accident happened, whether or not important statements were made, contact information, insurance information. So police crash reports are foundational oftentimes in police and personal injury cases. Now, they're not absolutely required, but they're oftentimes foundational. I'm not very happy about this change. The other thing is well, who determines what the threshold is? Meaning, who says it has what $1,500 is of damage versus 5,000? It's not like you're going to have experts and engineers coming out to determine that. It's actually going to be, in my understanding, made on an ad hoc basis by law enforcement. So it's going to be in their discretion a bit. And what's the teeth if they violate this? I honestly don't know, but this does set the policy. I don't like this because I think we should be encouraging law enforcement to be drafting police crash reports, not discouraging them. Now, I understand, I suspect the reason that this change was made is because police have a lot of work to do. They've got a lot of investigations. They've got a lot of reports to write. But I know in my own injury cases, you can have pretty devastating injuries resulting from what visually appears to be minor property damage. Sometimes underneath the hood of the car or, on the back end, there's way more than $1,500 or 5,000. So it just looks like it's minimal. But more importantly, you don't have to have significant property damage for somebody to be severely injured. You don't even have to have immediate knowledge on the part of the victim that they are injured to have severe injury. And I see this a lot in traumatic brain injury cases, but also other types of injuries. But in traumatic brain injury cases, particularly, the mechanics of the injury is you don't have to have huge damage. You can essentially have the brain that's floating in the skull being rocked back and forth and hitting the front and back of the skull. And you can have microscopic damage that's not appreciated immediately, that's not even seen on CT or MRI imaging, that over the months and years, folks are devastated from it. So I don't like this change. I wish we could reverse it, but again, that's not my, it's above my pay grade, but it is what it is. So it is there. So just be aware of that. The next one is, again, a nuanced civil statute. Traditionally, and this is the response of a recent case that came down, traditionally, let's say you're involved in a car accident case and somebody's charged with a reckless driving or a hit and run or something like that, and you have a personal injury claim. So let's say you've got a fractured wrist or whatever. In Virginia, you typically have a 2-year statute of limitations to file your personal injury case claim. Now, this is nuanced. There's other rules like claims against counties and claims against the Commonwealth. So take this generally for what it is. But generally speaking, there's a 2-year statute of limitations when you have a personal injury claim. This statute, 8.01-229K for personal injury, allowed a tolling of that statute of limitations while there was a pending criminal or traffic proceeding arising from that injury. So while that hit and run is pending, your statute of limitations, your personal injury didn't actually start running until that criminal or traffic case was resolved. There was a bit of nuance, though, because there was a case where it was actually a wrongful death. Somebody died, and then a criminal charge resulted. And there was, I think, an assumption that this statute reached wrongful death claims, not just personal injury. The court ended up dismissing a lawsuit because somebody for the wrongful death claim brought suit beyond the 2-year statute of limitations, assuming that this statute applied to wrongful death. And unfortunately, the Supreme Court, I believe, believe the Supreme Court said no, it did not apply to wrongful death cases, only to personal injury. And that's because the statute did not specifically refer to personal injury. From a plaintiff's attorney standpoint, I didn't like this ruling. From a human standpoint, I didn't like this ruling. From a textual standpoint, I understand where the court was coming from. And I think in that case, they also said, legislature, if you want to fix it, fix it. And that's what they did here. It appears to be that they're fixing that. So I'm glad that the statute was expanded to clarify that. Now, the last one I'm going to talk about, this deals with medical malpractice cases. Again, a very nuanced civil law. Traditionally, prior to July 1, and again, all this stuff doesn't come into effect until July 1. So in 2 days as I'm shooting this video, prior to this, when you filed a medical malpractice case, assuming it dealt with medical malpractice, there's some other, there's caveats when that's not required, but typically you're required to get an expert to certify that malpractice happened. This statute tightens those rules. Now, essentially, you're required to file that certification within 21 days after an answer upon service request. Essentially, you're automatically now required to file the certification. And it also, I think, simplifies and standardizes what the expert that you get is required, the language they're required to certify to. So I've added the language here, and it's in the statute, quote, based upon a reasonable understanding of the facts, the defendant for whom service of process has been requested deviated from the applicable standard of care, and the deviation was approximate cause of the injuries claimed. So just be aware what this means for you medical malpractice attorneys. There's been a tweak to the rule. Make sure to read it. Make sure to study it before you're filing your suit and all that. And frankly, I need to go back and read it in more detail because it's a bit of a change. And so super important. It can be one of these roadblocks or these gotcha moments that a defense attorney can use in a malpractice case. For you injury victims of medical malpractice, this is just a reminder. Medical malpractice claims are difficult, they're complex, they're expensive. One of the additional requirements in a medical malpractice case, beyond just a normal, let's say, car crash cases, before you can even actually initiate your lawsuit, you're essentially, before you can serve it, but honestly, you should, if you're the attorney, you shouldn't be waiting until service. You should just do it before filing, frankly. You're required to actually get a doctor to sign off on your claim. Whereas in a car crash, you're not required to. This is really just adding complexity, expense, and all that. So just another way, I think, to protect the medical field and doctors, and adding an extra layer of protection, an extra way your attorney can mess up a case, thereby messing up your claim. So just be aware of that. Medical malpractice cases are not easy, but the reality is if you are going to be pursuing a medical malpractice claim, unless there's caveats there, you're going to need to get experts involved to thoroughly make sure your claim is vetted and signed off on, because usually these cases are not going to be settled outside of litigation, particularly for devastating injuries. You're usually going to have to litigate them. So, I mean, getting the certification is kind of foundational, but you should expect to have to get a lot of thorough expert analysis and have a doctor come with you. So, folks, I hope this was useful. Again, there's, I'm sure, a ton of changes that I've missed. So this is really just trying to highlight a few that I thought were important, especially in the world of criminal defense, traffic, as well as personal injury. There's definitely nuances within these changes that I haven't caught, or maybe I haven't misunderstood. So if you see these, go and check the source themselves. Go look at the code itself. I think that's the best way to get a solid grasp of what's going on here. And again, every July 1, be on the lookout for changes in our laws. And again, just want to throw out a shout out to our elected officials working their butts off, taking time away from their family, friends, and work in order to help shape our laws. Let's keep going. There's a lot of work to be done, but this is definitely, most of these I think are in the right direction. So wish you guys the best. Have a great rest of your weekend.